Good morning, ladies and gentlemen. Our first case for argument this morning is Reporters Committee against Rokita. Ms. Lawrence.
May it please the court. Every day, law enforcement officers use their discretion to decide when to enforce certain laws. As this court recognized in Bell, laws are not vague simply because they require an officer to exercise some degree of judgment. While Indiana's buffer law, like most laws, does not require an officer to enforce it every time she could do so, it is not the type of impermissible law which allows officers to draft its terms each time they enforce it.
Ms. Lawrence, suppose an officer is walking down the sidewalk on his or her beat. Can that officer ask anyone walking towards him to move back 25 feet?
No, Your Honor, and I want to clarify why, because it's important that we look at the actual text of Indiana's buffer law. The buffer law does not allow an officer to tell anyone to move back or to disperse. The buffer law only allows an officer to tell someone to stop approaching. So if someone begins approaching an officer may tell someone to stop approaching her, and then she may remove herself further. Let's say someone has come within 10 feet. She may step 5 feet further and say, you may not approach any closer to me. She may not tell anyone to move back. And that's the justiciability problem here in this case, is that throughout their complaint, in their declarations, and in their briefing before this court, the Reporters Committee has consistently said that they have concerns with officers telling them to move back, to back away, to remove themselves to a media staging area.
None of that was the reason the district court held this law invalid, though.
That's correct, Your Honor.
District court held it invalid for a reason that's implied by my colleague's question, which is, what are the reasons an officer may tell somebody to stop approaching?
Well, Your Honor, the district court made two errors.
I didn't ask whether the district court made errors.
Yes.
I asked you for what reasons under this statute may an officer tell someone to stop approaching?
If an officer is conducting their official duties, an officer may tell someone to stop approaching.
In other words, for any reason.
If an
a good reason, a bad reason, an indifferent reason, a reason the officer makes up. The officer has just had a quarrel with a child, and he doesn't feel like having anybody near him. Are all of those reasons admissible under this statute?
Yes, an officer may tell someone to stop approaching within 25 feet of him or her under this statute.
Why
For
wouldn't
any
that
reason. Don't you have a trouble with that under Colander against Lawson?
No, Your Honor, we don't, because if we look at the Skilling test sets out two...
I didn't ask about Skilling. I asked about Colander against Lawson, and I wish you would address my question.
Yes, Your Honor. So the reason why we don't have a problem with that is that these types of laws are very different than the types of laws that the court addressed in cases like Colander, Morales, Papachristou. This court addressed, cited in Johnson, like the Ninth Circuit case of Desert Train, where they were allowing officers to stop someone for any reason and to arrest them for things like standing or for sitting in a car for otherwise or any reason.
Aren't there still fair notice and arbitrariness issues, though, based upon your answer, that any of those could be reasons?
No, Your Honor, there aren't, and there's two separate reasons for that. So the first reason for that is under Skilling, you have to look at whether someone has fair notice that they might be subject to an order. So if you're within 25 feet of a police officer, you may be subject to an order to stop approaching. That's different than the statute in Bell, because in Bell, the law said...
Everything you're saying was true in Colander. The dispersal statute in Colander said, if the police order you to move along, you must move along. It was perfectly clear what the populace had to do if the police issued the order. The problem, as the Supreme Court saw it, was that there were no standards under which the police could issue these orders. We have a parallel here. It's perfectly clear what the populace has to do if a police officer issues the order. But there doesn't appear to be any standard for the police officer to issue the order. That's why I was asking about Colander rather than some other case.
Your Honor, the key difference there is that in Colander, there is no triggering action. A person could just be standing there and an officer could tell them to disperse. That's not the case here because an officer must be conducting their official duties, and then the officer may only tell someone to stop approaching within 25
I guess
feet.
where we're trying to push is on the second prong that we need to get to of arbitrariness. If the officer is patrolling, simply walking down the street, the officer is at that point engaged in her official duties. So would this law restrict a citizen approaching the officer who is patrolling the streets?
The law may restrict a citizen from approaching an officer within 25 feet if an officer issues that order. And the big issue that the Supreme Court and this court looked at in Bell was whether someone
But go
could...
back to Colander, like what triggers the officer being able to enforce the buffer law?
If an officer is conducting their official duties, they are allowed to issue an order telling someone that they may not approach within 25 feet.
And are you asking us to reach that interpretation, that narrowing based upon the title of the statute? And secondarily, are we the court to do that, or should the Indiana court do it?
I want to clarify, this is not a narrowing of the statute. This is what the text of the statute says. The text of the statute says that if someone violates a do not approach order issued by an officer conducting engaged in their official duties. So that is the text of the statute. But the other issue that has arisen here is that because the Indiana legislature has adopted HB 1122, House Bill 1122, which the plaintiffs have not challenged, is that there now is yet another law in officers' toolkits which allows them to tell people to stop approaching within 25 feet. So Indiana has created these different laws that allow officers both to tell someone to leave an emergency scene. Those laws haven't been challenged. And then they also have passed a law that allows officers, when they believe someone might interfere with them conducting their duties, to stand back 25 feet.
So was it the representation of the state that Dash 14, which is the older version of the buffer law, and Dash 15, the one that was passed, House Bill 1122, is House Bill 1122 repealing the old law?
No, Your Honor. House Bill 1122 did not repeal the old law. Both laws are still in effect. And the Indiana General Assembly's decision to belt and suspenders the protections that they offer to law enforcement does not make the old buffer law, doesn't change the analysis there. The only thing that it changes are the potential redressability and ripeness problems for the claims that plaintiffs have brought when it's unable for us to determine whether the buffer law would actually apply to any of the issues that they are trying to raise here. And furthermore, it would be, it would not
How
be,
does that theory, though, align with the implied repeal doctrine that Indiana recognizes?
while Indiana does recognize the implied repeal doctrine, that is not at issue here because both laws can be in place simultaneously. Adding a narrower construction of a law does not constrain the broader interpretation of that law, and if that were an issue that has not yet been addressed by Indiana courts regarding these specific laws and hasn't been addressed.
So there's no inconsistency.
No, there's not an inconsistency. Just because an officer might say, for example, an officer might be in an emergency situation and say, hey, I need you to back away 25 feet from this car accident. And then someone starts coming up to the officer and the officer says, please stop approaching me. The officer might invoke both the emergency law and the buffer law at the same time, but that doesn't mean that the buffer law or the emergency law somehow repealed each other. They might work in tandem. So similarly, there might be an instance where an officer says, I'm trying to focus on this situation in front of me. I don't know what's going on. I need everyone to stop approaching me. There also might be an instance where an officer says, I don't have time to evaluate that right now. In this situation, I just need everyone to stop until we can evaluate what's going on. And in that place, House Bill 1122 and the original buffer law would both be appropriate. Now, if this court decided to agree, it also should not affirm the district court's injunction on First Amendment grounds, as the plaintiffs have argued. And there are a couple reasons for that. The first is whether this is a facial or an as-applied challenge to the law. The plaintiffs haven't made the appropriate...
Before we move away, though, to the First Amendment, the underlying First Amendment claims, I want to go back to in the brief, I noticed that the state represented that the buffer law overlaps the emergency incident statute.
Yes, Your Honor.
And then in the reply, it comes back and kind of walks that back. So I wanted to make sure I appreciated the state's position.
Yes, so the statutes, I would say they're interlocking. So there might be a situation where they both apply. There might be a situation where only one applies. For example, you can imagine a situation in which someone has set up crime tape and an officer is standing within 5 feet of that crime tape. There, the emergency law would say, I can tell you to move 25 feet away, but also the officer 5 feet in can say, stop approaching. You don't get any closer than 25 feet to me. Or there might be other situations where crime tape is set up and the officer is 100 yards away, and then the buffer law wouldn't apply because no one could enter within 100 yards of the officer without the buffer law. The reason why a First Amendment challenge would also not be appropriate here is that plaintiffs have not shown that a substantial number of the law's applications would outweigh its plainly legitimate sweep. And the main reason for that is that the plaintiffs talk about this law as though it only applies in public places. But the buffer law applies wherever officers are. So that may be in private residences, in non-public forums, in areas where the First Amendment protections are not implicated or are so low that it would be a very different analysis. They haven't done that analysis here. And further, it would be improper to affirm it on the as-applied challenge that they claim to have raised of non-obstructive news gathering, because no district court has made any findings or weighed the equities on what the range of that injunction, of what that would look like. And then the injunction itself bars the state and the city from enforcing the buffer law against anyone, anywhere, not only against people engaged in non-obstructive news gathering activities. And then finally,
Well, of course, there's a separate problem. You haven't challenged the universal injunction nature of this order, have you?
No, Your Honor, but we're
The Supreme Court's going to hear oral argument on Thursday about injunctions that reach non-parties.
Yes, Your Honor.
But I don't understand you to have made that argument here.
Well, Your Honor, to be clear, we are still a party to this case, but if the challenge is only an as-applied challenge, it would be improper to uphold a facial invalidity of the statute only if the only way that plaintiffs can succeed is on this narrow as-applied area. And if the court would, I would like to reserve the rest of my time for rebuttal.
Well, the district court entered a preliminary injunction.
Yes, Your Honor.
Is there anything that the state wants to show at a hearing on a permanent injunction?
Yes, Your Honor, especially if we were discussing the First Amendment issue. So that discussion would be, plaintiffs have said that they wish to be within a few feet of police officers. So that would require evidence of the technology that's available. Other district courts, as this court is currently deciding the Nicodemus case, found that wasn't.
I'm not sure you heard my question. Is there anything the state wants to show? You may think the plaintiffs haven't shown what they need to show. I am asking you whether there is anything the state wants to show.
Yes, Your Honor, that would include testimony from officers and showing what these type of circumstances actually are like and the necessity for this law in certain circumstances and why it may be required. Thank you.
Mr. Clary.
Thank you, Your Honor, and may it please the court. Under the statute that the district court found unconstitutionally vague here, any law enforcement officer in Indiana can bar any member of the public from getting within 25 feet.
Can the statute be interpreted in a way so an officer may only give an order to move back when that officer is engaged in official duties?
Well, I think in engaged in official duties, I agree with the state. That's what the statute says. The problem is engaged in official duties sweeps in everything law enforcement officers do on the job. What it doesn't require, and what the state agrees it doesn't require, is any showing that the individual's presence, in fact, interferes with law enforcement officers' ability to perform their duties. And I think the contrast with Indiana's new 25-foot law makes that clear, since the new law requires reasonable grounds to believe an individual's presence will interfere with law enforcement duties. And I think the contrast highlights the statute the district court was addressing here. It has no nexus to interference. It has no nexus to safety. It has no nexus to any of the interests that Indiana suggests would justify it. And I heard my colleague on the other side agree in response to Judge Easterbrook's question. An officer can issue an order to stop approaching for any reason or for no reason under the law as written. That's the same constitutional flaw the Supreme Court condemned in Shuttlesworth, in Morales, that this court likewise condemned in Bell versus Keating. So I don't think there's any way to read the statute that avoids that difficulty, as the state appears to agree with us.
If there's going to be a narrowing that's going to go on, where should that happen? This court, Indiana courts?
So I don't think the statute is susceptible to a narrowing construction, but if this court disagreed on that front, I think this court and the Supreme Court have often emphasized that waiting for a state court to supply a narrowing construction when you have a standardless statute that threatens to chill speech in the meantime would be inappropriate. You need a prompt adjudication in federal court because otherwise individuals are waiting and guessing what their rights are and engaging in self-censorship while that clarity is lacking. That was the case in City of Houston v. Hill, dealing with heckling police officers, where the state had likewise urged an opportunity to interpret the statute, and the Supreme Court said, no, that'll chill too much speech. I think it's true here as well. There's no obvious place in the text to fit a narrowing construction. As Indiana said repeatedly before you just now, if the officer is engaged in their duties and if an individual is within 25 feet, they can be ordered to stop approaching on pain of arrest and criminal prosecution. I just don't see where a state court would be in a position to supply a meaning other than the one that we all appear to agree on here. Given those defects on the merits, I'd like to spend a little bit of time addressing the standing issues to which my colleague addressed most of her argument. And if I could, I'd sort of emphasize one point on the law, one point on the record in this case, and then one point on the practicalities of Indiana's position. On the law, I think for all that Indiana speculates that maybe the instructions our reporters received were not under this statute or were voluntary requests rather than orders, this court's case law is clear. We wouldn't have needed to demonstrate evidence that we in fact received an order to stop approaching if we credibly allege that we want to do the conduct that triggers the statute, and there's a credible threat of enforcement if we do. So no individualized threat of enforcement would have been necessary to satisfy Article 3 because, as this court put it in Majors v. Abel, the threat is latent in the existence of the statute. But we did go further, and I want to emphasize that as I think Judge Easterbrook was mentioning earlier, the district court made a factual finding that our reporters, in fact, received instructions to back up that would have triggered the application of this act after it passed. That's page 11 of the supplemental appendix. And if you look at the declarations in the record on which the district court based that conclusion, one from Ryan Fedwall, who's a photographer for WTHR, one from his newsroom director for WTHR, they both described not just that they were in scenarios where they were in public, they approached within 25 feet of officers, and told that they ought to back up, but that those encounters unfolded in circumstances where members of the public were being allowed to approach closer. In other words, where there was no fixed perimeter in effect. And as the state itself has argued to this court in the Nicodemus proceeding, the emergency incident law only applies when law enforcement is enforcing a fixed perimeter. So those incidents that are described in the record could not have been examples of the emergency incident law being enforced. The only law that would have empowered officers to order our reporters back under those circumstances would be the buffer zone law. So I think we went well beyond what Article 3 would have required on that front by presenting evidence that, in fact, the statute has already, on a number of occasions, been enforced against our reporters under circumstances that required them to forfeit their opportunity to exercise First Amendment rights.
If we move away from the injury in fact, see if accepting you satisfy both credible threat as well as self-censorship, my focus on the redressability position that the state has made is that now that this new statute is in place. And so if you could just address that in the minutes that you have, I'd appreciate it. On
Sure.
the addressability.
I think the problem for that argument is that, as the state agreed, the two laws have different scopes. And so the existing 25-foot law continues to injure our clients if the preliminary injunction weren't in effect, in circumstances where the new law won't apply. And those are the circumstances where their First Amendment rights are most at stake, because the new law only applies if an officer has reasonable grounds to believe an individual's presence will interfere with law enforcement. So we would still be injured by enforcement of the old law in all of the circumstances in which our reporters approach within 25 feet of law enforcement, and there is no reasonable basis to believe that they would interfere with the officer's performance
And as
of
long
our
as
duties.
what I'm calling the older buffer law, or Dash 14, is still applicable, then that would be possible. Not
That's right.
needing- okay.
Yes, officers would still have the authority under those circumstances to order them to stop approaching for any reason or no reason. They still face the risk of jail time, arrest, prosecution if they approach in those circumstances. That injury flows from the old law, not the new one, and redressability does not require complete relief. It's enough that there are circumstances in which we've presented evidence, we face a credible threat that the old buffer law, rather than a different Indiana statute, will be enforced against us. And in those circumstances, the preliminary injunction relieves the law's chilling effect.
Shifting to the committee, is there a standing problem for the committee under the Alliance for Hippocratic Medicine case? I take a look at the complaint, specifically paragraphs 46 through 50. Are they doing much more than publishing new materials on the website?
I agree with you. It's a much closer question after Alliance for Hippocratic Medicine. And I think you would need to toss out of the analysis some of the allegations we made under previously existing law that deal with issue advocacy rather than the direct provision of services. I think the Reporters Committee is probably still on the right side of the line because of the distinction the Supreme Court drew between organizations that are really just saying, I advocate on this issue, and advocating has gotten harder, and organizations like the one at issue in Havens Realty itself that provided direct services. And the Reporters Committee's mission primarily involves providing direct legal services to journalists.
But here, there's not an actual expenditure of funds, at least yet. It indicates in paragraph 48, intend to host additional trainings. Observed an increase in arrests, but at this juncture, is there enough for the committee to be on that right side of Havens Realty?
Well, the standing would be assessed at the time the complaint was filed, and subsequent developments would go, if anything, to mootness rather than to standing in the first instance. If the court was interested in more information about what's happened in the interim, I'm happy to ask my colleagues who deal with our training practice and our new local legal initiative attorney in Indiana. But I think the main point I'd emphasize in connection with Alliance for Hippocratic Medicine is standing is a much more straightforward question for all of the news organization plaintiffs who are engaging in news gathering within 25 feet of law enforcement officers every day of the week. They're getting told to back up several times a week, as the declaration from Scott Hums shows, and the act attaches new criminal penalties to that conduct. And as the court knows, as long as one plaintiff has standing, the district court had the power to adjudicate the case. The other point I do want to emphasize on standing is the brass tacks practical consequences of what I take to be Indiana's view. Because imagine the paradigmatic interaction that unfolds between a member of the public or a journalist who encounter each other on the street. You approach within 25 feet, you're out in public, you're minding your own business, maybe you're going to a political rally or something like that where law enforcement are present. Law enforcement officer says to you, hey, I'm gonna need you to stand over there. Now, have you just received an order that's going to send you to jail and get you criminally prosecuted if you defy it? Well, the act at issue here doesn't require officers to use any magic words. It certainly doesn't require them to reference this statute in particular. And it doesn't require them to warn you twice. So the only way you're going to learn to a scientific certainty which law they thought they were enforcing in the privacy of their hearts is if you defy that instruction, get arrested, get charged, and learn from the charging document which statute the officer says was at issue. But risking arrest and prosecution is exactly what this court and the Supreme Court have repeatedly said a plaintiff does not need to do before bringing a challenge to a statute that on its face regulates First Amendment conduct in which they want to engage. That's exactly the situation we have here. There's no dispute that when our reporters approach within 25 feet of law enforcement officers, that triggers the authority to order them to stop approaching. That order threatens to send them to jail. And like other objectively reasonable people, the record shows that what our reporters have done in response is err on the side of caution, forfeit opportunities to exercise their First Amendment rights because they would rather not spend the night in jail to test the question. That's a classic chilling effect injury for purposes of Article 3. I'm happy to field other questions the court might have on the merits. The last point I would throw into the mix is on this interpretive question about whether the statute says you can be ordered just to stop approaching or also to move back, because I do think the state's position on appeal here is new. If you look at their briefing in the district court, their motion to dismiss, for instance, when they offer examples of the statute being enforced, are, I believe, all, but certainly most examples of officers telling people to move back. And I think
Does anything in the statute say the police can order people to move back?
I think in context, in an ordinary language sense, to approach just means to draw closer. Doesn't necessarily
Right.
prejudge
No,
who is moving.
you say nothing in the statute would allow a saving construction. Nothing in the statute allows anybody to order somebody to move back. It is what it is.
Well, the next point I wanted to take that, which maybe responds to your observation here, is with those caveats, I'm not sure the distinction has any stakes. I don't think it has stakes for standing, because if you've been told you have to move back, you've necessarily also been told you can't get any closer. And so that's enough to trigger liability under the statute if you go on and you decide to approach regardless. And I'm not sure it matters on the merits, because you would still need a standard to decide who gets ordered to stop approaching, even if you can't order them to move back. And for First Amendment purposes, you'd still be prohibiting substantially protected speech rather than harmful conduct.
Suppose the statute were amended tomorrow to say that the police may order somebody to stop approaching when necessary in the course of their official duties. Would that make you happy?
I think you might still have vagueness problems at the margins
Yes, you
about
would.
what the duties are.
In your view, what would you not have vagueness problems with?
Well, I think the
If
new
you put in a
statute.
necessity requirement, you would think that's pretty strict. But it's not self-defining. It turns out there are very few things in language that are self-defining. Do you have language that you think should be in this statute?
So I want to be clear. I think the new Indiana 25-foot law is not vague. And my only reason for hesitating on your question about necessary was not to do with how much we get out of necessary, but how much clarity we get out of necessary to their official duties, right? What's the sense in which the order is necessary to their official duties? I think the new law, and I'm conscious I'm running low on time, but I want to answer any questions the court might have. We would happily agree the new law is not vague because that reasonable grounds to believe a person's presence will in fact interfere with an officer's duties tells both officers and the members of the public what kind of conduct you're looking out for. You're concerned about interference. You're concerned about some actual practical obstacle.
Thank you, counsel.
We'd ask the court to affirm.
Anything further, Ms. Lawrence?
If I may, Your Honor, I'd like to specifically discuss the Colander point and whether there are standards in the law here that are different than the standards that existed in Colander. The problem there was that the law allowed officers to ask for credible and reliable forms of identification. So an officer one could see a form of identification and say, this is credible and reliable, you're free to go. Officer two could look at the same ID card and say, ooh, this is not credible and reliable, you're arrested. In this situation, if someone has received an order from
That
an
wasn't the
officer,
problem the Supreme Court had in Colander. The problem was there were no standards for the officer's commands.
there were no standards because the officer could use any standard in determining
The
whether.
officer could do it because he had a bad breakfast.
Yes.
And you've already answered my question that the officer can order somebody to stop approaching because he had a bad breakfast.
That would be permissible. That would be something that the law allows if an officer is conducting his official duties. The other issue, though, I would like to raise is that if there are as applied concerns with a specific issue of arbitrary enforcement in a specific instance or discriminatory enforcement, those can be brought as applied challenges. We would ask this court to vacate the injunction.
Thank you.
Thank you, counsel. The case is taken under advisement. We'll hear argument next in the case of Dotson against Faulkner. Mr. Small. Please proceed, Mr. Small.
Thank you, Your Honor. Good morning, Your Honors. And may it please the court, my name is Scott Small. I, along with my co-counsel, Jude Witkowski, will be arguing on behalf of Appellant Ladita Dotson. I will be handling the scope of employment issue. The first question that this court needs to address today is whether
Why
or
is
not...
this issue present?
Sorry?
Why is this issue present? Why does scope of employment matter,
Scope of
given the
employment-
identity of the defendants?
Scope of employment matters, Your Honor, because the Wisconsin State Indemnification Statute requires that...
No, listen to my question. Why does it matter given the identity of the defendants? The district court said it doesn't matter because the potential indemnifier is not a party. Your brief completely ignores the ground on which the district court decided this issue. And now I'm asking you to address it.
The district court, Your Honor, thank you, denied Ms. Dotson's ability to argue the issue of scope of employment, in part because the district court believed that the incorrect parties were named in the lawsuit in general, but also that the state actors were dismissed from the case. However, the claim itself,
No,
the
the indemnitor would be the employer. Scope of employment matters when the employer is asked to indemnify. The employer is not a party. That's your problem.
There is case law, Your Honor, and I know that it was not referenced in the brief. I'd be happy to supplement the record.
It's too
with
late now.
The issue of scope of employment itself is not the claim. It's the theory of liability that we bring to enforce the judgment that we already have in default against the defendant, James Faulkner.
If you're going to try to collect the judgment from someone who is not now a party, you need to file a separate piece of litigation against that person. In that suit, scope of employment might matter. In a bankruptcy of Faulkner, scope of employment might matter. You might ask the bankruptcy judge to assign Faulkner's rights to your client. But none of that matters to this suit, and this suit is the only one that is before us.
Your Honor, we disagree with that analysis of when scope of employment would apply to a certain claim and when it would apply to a certain judgment. Our research and case law indicates that scope of employment is something that can be brought up at any point in time throughout the litigation, including at the damages hearing.
Well, that would be interesting if you had raised such an argument in your brief, but you did not. It has been forfeited. It's a perfectly normal consequence of failing to argue a point in a brief. If you think the district court has made a mistake, You must address that in your brief. You don't simply ignore it and go on as before. That's unprofessional conduct.
Your Honor, the district court declined to even rule on the issue of scope of
And he
employment.
gave a reason that the employer was not a party. And if you think that reason is incorrect, you must address it in your brief rather than ignore it.
The question that we're asking this court to decide, Your Honor, is whether or not she should even have the opportunity to decide
We
the
are
scope of
not
employment.
going to address it, counsel, because it wasn't raised in your brief. I hope you're getting the point by now.
I understand, Your Honor. I will reserve the rest of my argument for...
There is nothing else for you to argue. Mr. Witkowski.
Thank you, Your Honors, and may it please the court. My name is Attorney Jude Witkowski, and as Attorney Small stated, I'm here on behalf of the appellant addressing the remaining issues before us today. I would like to start with the admissibility of expert Dr. Leighton Foles' sworn statement, specifically as it pertains to Chapter 28, Section 1746.
What's the standard of review?
The standard of review here is substantial compliance with...
Why not abuse of discretion?
Oh, I'm sorry. The standard of review is abuse of discretion. That is correct. I mean the standard of essentially whether or not a sworn statement is allowed and acceptable pursuant to Section 1746. That being substantial compliance. Not
Wouldn't that
No, substantial compliance is the statutory standard
Correct.
for the district court. My colleague is asking you about the standard of appellate review.
Yes, Your Honor. May you please rephrase the question, please?
I'm sorry?
May you please rephrase the question, please? One more time.
All right, so the parties suggest that when we're looking at this issue under 1746, that our standard of review for determining whether or not that the district court was correct in not admitting it is de novo.
Certainly. And we
And
are
so
saying...
my question is asking, should we be using de novo review or abuse of discretion?
Oh, it's an abuse of discretion standard, Your Honor. And here we believe that the lower court abused its discretion when they denied, essentially stating that the sworn statement was not in substantial compliance with 1746.
Aren't we going to engage in a slightly different view if it's, for example, a pro se declaration versus Mr. Seifert's declaration?
I wouldn't say a slightly different view. Perhaps there may be an intrinsic higher standard for somebody in a situation where they are more familiar with submitting these types of statements.
But, I mean, federal courts get hundreds of these declarations filed every day, every week, without 1746 problems. This is the problem for this case, is the issue with regard to the use of the word true and correct in this particular case.
Yes, that seems to be the sole issue with regard to this sworn statement, is that the true and correct does appear in a paragraph instead at the beginning. But it's this very court that said that these hyper-technicalities are not things that should be fixated on.
And that goes to my question about pro se versus a lawyer. Lawyers who file these every day in every federal court across the country don't have this problem. Why is that problem exist here?
Honestly, Your Honor, I did not draft it. The language was saying it was true and correct as it pertains to the expert report into the plan. That was why Dr. Leighton Foles was retained in the first place. The truth is of her statement that she was making within the plan.
The judge gives you 14 days to make sure that it's in compliance. Under penalty of perjury, true and correct. How did the district judge abuse their discretion in not admitting this document?
Well, we believe that this was a narrow interpretation of 1746 and that it was, well, as I said, narrow. We viewed case law across the country through several circuits and district courts, and there's variations all across the nation which determine what is true and correct, what must be deemed true and correct. Some case that we see, I believe it was cited in Roy v. Ivey, where there were ideas that it just needed to say that the statement was true. Right, and what the nexus of this report and this plan...
Has our circuit answered this question already?
I believe your circuit has spoken as to the rigidity and its, I would say, reluctance to a narrow interpretation based upon its opinion in Field v. Rogers. However, on this precise issue in this case, no. if I may, I'd like to continue to move on to our next pressing issue, that being the present day value calculation submitted by Attorney
So,
Joseph.
I'm sorry, before
Yes.
we move away from the declaration, is it your representation that penalty, under penalty of perjury was also included?
Within the sworn statement, Debbie Leighton Thal, under the penalty of perjury, states the following, is the language that was included. So we do see that. We do see a name, we do see a date, we do see the words true and correct as it refers to document 1N, that being the expert report plan.
We see it where? In the declaration?
Yes. As I was, I believe.
Present value
Yes,
calculation?
yes. So, just for background setting, Attorney Joseph Seifert was ordered by the lower
No,
court.
we didn't ask for background. Your time has expired. You must answer the question, but otherwise you are out of time.
Yes, Your Honor. Thank you.
Ms. Juris, I have a simple question for you, which is, why are you here? Since the appellant's brief didn't ask for any relief against any of your clients.
Well, I think that's a very fair question, Your Honor, and ultimately the reason that we're here relates to Dotson's late stage and improper attempt to litigate the indemnification claim. And so really we're here to preserve our arguments that the district court was correct in holding that she cannot show any abuse of discretion by the district court declining to consider that. We know under 895-46, that being the Wisconsin statute, the state has an opportunity to be heard on questions of scope of employment. And so that's why we're here. Now, as to our arguments about the other issues, those are really preserving arguments in defense of the
Count them as
district court.
preserved.
And fair enough, and so I don't intend to present, unless the court has any questions for me about those other points, I don't intend to present any arguments on those questions.
Okay. Thank you very much.
Okay, thank you.
Mr. Small, technically you have time remaining, but you don't have an argument. Is there anything further you wish to say?
We'll withdraw our time for rebuttal. Thank you.
Thank you.
Thank you very much. The case is taken under advisement. We'll hear argument next in the case of Cormie against Lee.
Good morning, may it please the court. My name is Alan.
Mr. Mandel, you should speak when you're at the rostrum.
Good morning,
Morning.
and may it please the court. My name is Alan Mandel. I represent the plaintiff in this case, the appellant in this case, Megan Cormie. She is in the courtroom with us, as well as my trial partner, Joe.
I'm sorry, it's hard for me to hear you.
I'm
Can you? Thank
yes,
you.
I'm very sorry.
No problem.
So, our appeal poses two legal issues which touch on federal statutes, Section 1988, cases interpreting Section 1988, federal public policies with respect to the client's incentives to enforce their civil rights, Illinois common law, Illinois public policy.
Counsel, why does Illinois law matter? This is a case under a federal statute, 1988. Why does Illinois law contribute at all?
We believe the leading case, the one that we're asking you specifically to follow, is Pony.
Yeah.
And the analysis in
Before
Pony
you
is-
cite a particular case,
Yes.
you need to tell us why Illinois law matters.
going back to 1897, Illinois law, the Illinois Supreme Court, has found that.
No, look, you cannot tell me what the state court has found. You need to tell me why, as a matter of federal law, we should be looking to state law.
As I read the analysis of the federal courts, the underlying state law with respect to whether or not a personal injury claim may be assigned is a fundamental aspect of the analysis here.
I don't understand it. Evans against Jeff D. says that as a matter of federal law, the client has the property right to the attorney's fee award. Now, where does state law then get in, since Evans is a decision under federal law?
Well, Evans didn't deal with an assignment. The cases that deal with an assignment note that the statute itself does not make a finding with respect to whether or not the Supreme Court has said a number of times a 1983 Act claim is a personal injury claim. And there was an open
For
question.
purposes of the statute of limitations, but accrual is a matter of federal law, and all the substance under 1983 is a matter of federal law. I don't think you're getting the gist of my question.
There's
But anyway, please proceed.
No, fair enough, Your Honor. There is no federal case that holds that the attorney's fees provisions under Section 1988 are not substantive claims that can't be assigned. I guess I'm asking this court to find, as the Pony Court did, that there is a syllogism between federal law, which says it's the client's...
Let me ask a different question. What is the difference between an assignment of the 1988 claim and a promise to pay over to the attorney whatever the client is awarded under Section 1988?
And that's covered in Pony in a number of cases. There's a difference between...
I'm not asking you about a number of cases. I'm asking you to explain what you see as the difference between these two things.
There is a difference between assigning a percentage of the recovery of a case from assigning a substantive right. And if the client and the attorney are in alignment, you don't have a problem. When the attorney takes a substantive right...
Excuse me. I've asked you to explain the difference, and you've responded by saying, well, there is a difference. Can you explain what you see as the difference?
If I assign a 33% interest in the recovery...
No, look. Listen to my question, please. What is the difference between assigning to the lawyer all of the attorney's fees recovery under Section 1988 and promising to pay the lawyer all of the attorney's fees recovered under Section 1988?
Client consent.
Pardon?
Client consent.
No. We are assuming the client has consented to either of these agreements. What is the difference between these two agreements?
The first agreement, a contingent fee agreement, does not give...
I'm not asking about contingent fees. You didn't listen to my question. Section 1988 has nothing to do with contingent fees. Let me give the question again. What is the difference between assigning to the lawyer all of the money awarded by a district court under Section 1988 and promising to pay the lawyer all of the money awarded by the district court under Section 1988?
I believe, I'm going to give it my best shot. I believe the difference is who controls the claim, and under Jeff D., as you pointed out, it's the client's claim to control or to waive. And if the client is not advised with respect to those rights, as happened in Pony, then there's a big difference between...
You haven't explained what that difference is. In either event, the lawyer ends up with all of the money awarded by the district court under Section 1988. The client gets the principal recovery, and the lawyer gets the money under both of these options. What am I missing? Why is there any difference?
I believe the problem in this case is to what extent could an assignment, not a contingent fee agreement, an assignment be...
There are no contingent fees under 1988. There are no contingent fees in this case.
Under the assignment at issue here, the client lost control of her settlement. And that's specifically referred to in Jeff D., and that's specifically emphasized by the threat towards the end of the representation that we will enforce to the full extent of the law our assignment. And there is no case, Your Honor, which defines the full extent of the law to which
You
an
just
assignment...
haven't explained what the difference between these two legal mechanisms is.
It's
I
control-
understand your argument that threats were made in this case. That went to a jury trial at which your client lost. I'm just trying to figure out what, in principle, is the difference between an assignment and a promise to pay, where the promise to pay can be enforced by a lien on the attorney's fees.
The client loses control of the right to settle her case on her terms. She loses her control to, as Jeff D. found, to waive her claim for fees.
Can you tell me at what point did or do the attorneys, I guess, fiduciary duty kick in regards to the assignment?
So under Illinois law, and I believe federal law as well, if the attorney has unique and specialized information that has a material effect on the representation, then what's required is full disclosure of that information, a written suggestion that the client seek independent legal advice, and thirdly, that the transaction, the assignment itself, was fair in fact.
That speaks to confidentiality more than it speaks to fiduciary duty, though, doesn't it?
No.
And what Judge Pryor's question is trying to pin down what appellant's position is as to when that fiduciary duty kicks in.
Right. And
For example, place that question on these facts. When do you say that happened?
when they negotiated for the assignment, at the same time they negotiated separately a retention agreement.
And how many, this is after the 15 hours of review by your clients?
Yes. Not by my clients, by the defendants.
By the defendants, I'm sorry. Yeah.
Yes. The fiduciary duty, which is a more subtle question than the simple enforceability of the assignment, the fiduciary duty is a more nuanced analysis, but it really turns on the disparity of information between the lawyer and the client at the time.
But isn't that every client?
I beg your pardon?
You would always have a fiduciary duty with every client based on your representation, because I haven't heard you articulate what special information, I know you're wanting to analogize it to the Cormier case, was here, that was present.
The special information is, as Mr. Lee knew, that no court of appeal had upheld the assignment. Many had questioned it. Some state courts had found it unethical. Some federal circuit courts had found it void and unenforceable. If you're going to offer...
But in the Seventh Circuit,
Yes. The Seventh Circuit hasn't ruled on this issue, but if I could talk about Pony for a second. The lawyer in Pony, whose assignment was found to be void and unenforceable, had a much different assignment clause, because it says not only is the client waiving all rights to prevailing party status, to obtain a judgment, collect, receive statutory attorney's fees, etc., but there's a disclaimer in Pony that you won't find here that I think is dispositive. Client acknowledges and agrees that the foregoing assignment and transfer may make it more difficult for client to settle the case because client will not possess the powers or rights to waive, apply for, obtain judgment, collect, or receive the attorney's fee award. Now, Mr. Mitchell in the Pony case understood what our ethics expert wanted to bring to the light of the court, which is there is an inherent conflict of interest
But
when
in
a
Martin,
lawyer takes
there was an
I beg your pardon?
adoption. Yeah, in Martin, though, there was an adoption of the restatement second of agency, under agency law, and said there must be a peculiar trust and confidence.
That's with respect to a stockbroker. The law is that when a
And we're
client,
trying to apply it in this context.
Right,
So
we're-
I'm trying to follow the argument this morning of why are we able to pull it from that context and apply it here?
as a matter of law, an attorney-client relationship is a fiduciary relationship where the client must necessarily.
Once the attorney is retained, once the attorney-client relationship is established, I'm asking, when does the fiduciary duty on these facts, looking at the restatement, would have applied here?
When the attorney asks for an assignment that has never been approved by any court, found unethical by 5 different state ethics panels, and has been found void and unenforceable by at least 2 federal circuit courts.
I'm sorry, you've given a different answer to Judge Pryor than you gave to me on timing of fiduciary.
I apologize. How did my answer differ?
Because you're invoking other state authorities with regard to when it was. You told me it was after the study that the appellees had done and made their timing.
I apologize. I misunderstood your question.
All right.
To be clear, the work they did beforehand is not relevant. What's relevant is the day they present the assignment but don't explain it with specialized knowledge as to its unenforceability, or at least its questionable enforceability, is when the fiduciary duty triggers under Martin, under the bankruptcy court's decision in Carr, which found pre-existing fiduciary duties as it relates to lawyers negotiating their fee agreements. You can't hand a client a loaded gun and say, don't worry about this, but I have it, and you can trust that I'll use it only for your benefit. If there are no other questions, I shall wait for rebuttal. Thank you.
Certainly, Mr. Mandel. Mr. Meyer.
Morning. May it please the court. Morning. I'm Dan Meyer. I represent Mr. Lee in the underlying matter in here. My intent this morning is to address the fiduciary questions and specifically whether or not a generalized fiduciary duty arises before the formation of the attorney-client relationship. And respectfully, I'll suggest to the court that it does not. The general rule is that an attorney owes fiduciary duties during the attorney-client relationship, but not before that relationship is formed and not after it has been terminated. There have been exceptions. I'll call them exceptions. I think more accurately what I mean to say is that there have been instances when the courts have imposed upon a lawyer a certain duty, whether you call it a fiduciary duty, an ethics duty, or some other type of duty, is more or less besides the point. But there are certain instances, where that has occurred. But if you look at the case law and the language of the case law in those instances, every one of them finds their source in ethics. They find their source in the rules of professional conduct. I'd like to start, if I may, with the general rule. This court, roughly 15 years ago in Maxim, addressed a very similar issue that we're dealing with here and asked the question, when, to one of the questions that was asked of my friend earlier, when does the attorney-client relationship begin? Maxim states the generalized rule that there is a presumption of invalidity when an attorney engages in a business transaction with a client during the relationship. But that doesn't move the ball on the topic that we're addressing today. The question is, when does that attorney-client relationship begin? As the district court noted in this case, and I'm going to quote, fiduciary law does not send the dark cloud of presumptive impropriety over the contract that established the fiduciary relationship in the first place and fixes the terms of compensation for it. And the district court was quoting Maxim. Maxim then raises the question, well, when does that relationship begin? We know here that an attorney-client engagement letter was executed by both the appellant and appellees in January. The fiduciary duty that they're attempting to enforce through the district court action and before this court attaches, so the argument goes, well before that point in time. The state court case, the Illinois Supreme Court case of Pagano, though, addresses the question of when the attorney-client relationship begins, when it ends, and when the fiduciary duties attach. Pagano stated very clearly that the fiduciary duty attaches upon the commencement of the relationship. And there is no fiduciary duty prior to that, so not a generalized fiduciary duty prior to that. We, of course, know that there are instances where that duty has attached earlier. They're very specific instances, though. Before I get to those, I do want to address the two Martin cases from the Illinois Supreme Court. My friend contends before this court and before the district court that those cases are somehow dispositive. He contends that they establish as a matter of law.
What do you say about the question that I asked Mr. Mandel about why state law is relevant?
I think state law is relevant to this question because the district court was sitting in diversity jurisdiction. That was the only reason why, that was the only basis for its jurisdiction. This is a legal malpractice case mixed with fiduciary duty issues. The underlying case was a Title VII case, which would, of course, give federal jurisdiction to the district court. But the malpractice case was premised solely on diversity of citizenship.
This assignment was negotiated in connection with a case that would be litigated under federal law, where federal law determines the amount and recipient of fees. Why should the law change in a follow-up suit? If something was governed by federal law initially, why would it get to be governed by state law later on?
I don't think that the question of the fiduciary duty was an issue in the underlying case, meaning the 1983 case did not involve a question of whether there was a fiduciary duty between Ms. Cormie on the one hand, the appellant, and the appellees on the other. That issue only arose in the follow-on proceeding. That was a diversity jurisdiction proceeding, and I think state law does assist the court. I understand your point. To me, I'm not saying that your point doesn't matter. I do not want my next comment to be misinterpreted. But I think both federal law through cases like Maxim and the district court opinion in Block and the state law, as evidenced through, Pagano, are the same. So to be blunt and simple, it does not matter to me whether the court applies federal law, meaning Maxim, or state law, meaning Pagano, because the outcome remains the same. I do want to I'm going to cede my time here in a moment, and I want to address these instances, and I'm going to do it briefly, where our courts have imposed a duty on a lawyer prior to the formation of the attorney-client relationship. Westinghouse is one of them, as a Seventh Circuit case. That goes to one of the questions the panel asked earlier about confidentiality. Westinghouse is simply the pre-Rule 1.18 Rule of Professional Conduct. Westinghouse says that when a lawyer receives information in confidence from a non-client, the lawyer cannot then use that information against that non-client in later litigation. That's what Rule 1.18 does. But Rule 1.18 relates to prospective clients. Our Supreme Court, the Illinois Supreme Court, in drafting that rule and adopting it in 2010, addressed that question, added that rule in, so that it is clear what protections a prospective client gets. And it was very limited in affording those protections. Don't use confidential information against somebody who has given it to you. It did not give any broader rights. And I'm running out of time.
Thank you, counsel.
I don't even think I can complete a thought, so I'll cede my time. We do ask that the court affirm the district court's judgment. Thank you.
Ms. Hamilton.
Good morning, Your Honors and Counsel, and may it please the Court. My name is Amanda Hamilton, and I represent Defendant Appellee Antoinette Choate, and I will be speaking as to the assignment issue. In requesting a reversal of the jury's verdict in the district court's orders, plaintiff requests that you find that an assignment of the right to collect attorney's fees pursuant to Title VII is against public policy. Further, the plaintiff requests that you reverse the district court and the jury's verdict and find that an assignment of the right to collect those attorney's fees is independent grounds for a separate claim for a breach of fiduciary duty. Respectfully, this request has no basis in the statute or in the case law, and the district court's order should be affirmed. Now, in permitting the award of attorney's fees and discrimination claims, this court and others has recognized the need to incentivize attorneys to
Should we jump right in and answer the question of why is state law relevant?
Honestly, I think that federal law is dispositive as to the assignment issue, and I think this court's decision in Pickett in particular, that would be Pickett v. Sheridan Healthcare Centers, is dispositive as to that issue. For example, this court in Pickett went through the legislative history and the need to incentivize attorneys to take on these types of cases. And in Pickett, for example, the attorney had a flat fee agreement where he would get $7,500. He also had an agreement in his retainer that he would receive 1/3 of the total amount recovered for his client. And then he also had a provision saying that he was going to take 100% of the statutory attorney's fees provided. Now, in that instance, the plaintiff was a housekeeper who claimed sexual harassment, and she was ultimately awarded $65,000 in damages. The attorney sought $131,000 in attorney's fees. And this court, in finding, in evaluating the propriety of the total fee and the fee agreement, found that the attorney is separately entitled to both a contingency fee and an assignment of the statutory fees, saying, quote, private fee agreements and statutory fee awards can coexist, and that a plaintiff is free to contract with her attorney to pay a contingent fee in addition to assigning rights to the statutory fee. That's on page 643. This court specifically held to hold otherwise impedes plaintiff's right to contract and plaintiff's ability to attract competent counsel. And the purpose is to secure competent counsel. Now, Your Honors, I'd like to note that in footnote 5 of that opinion, this court noted that it was somewhat concerned that the plaintiff in that case was an unsophisticated party, and there was maybe a question as to whether or not she understood the, quote, steep compensation agreement. However, this court noted that the Eighth Circuit in Ross v. Douglas County found that the only appropriate agreement would be where the attorney would receive the greater of the two, i.e. either the statutory award of attorney's fees or the contingent fee agreement, but instead said, quote, although we believe that a contingent fee contract that allows for an offset can be more just, we cannot conclude that an offset provision is legally required. Now, in this case, plaintiff was a sophisticated party. She had an undergraduate degree in business, she had an MBA, and she previously had engaged an attorney to pursue a separate set of discrimination claims against a separate employer and had settled those claims. That's at docket number 575-20, pages 4 and 5. Moreover, the plaintiff had previously engaged a different attorney in her same case against Deloitte in this underlying case, Mr. Drew Peel. And notably, the engagement agreement with Mr. Peel provided for a flat fee, 100% of all statutory fees awarded, and a 35% contingency fee amount of any other amount recovered. That's at docket number 575-21. Now here, the retainer agreement that plaintiff signed with defendants is exactly what this court referred to in Pickett as just. It provided for an advanced retainer plus 1/3 of anything recovered over $40,000. It also provided that the defendants would reduce dollar for dollar any amount of the contingency fee owed by Cormy for every dollar they were awarded in statutory attorney's fees.
Defendant's fee agreement therefore included the offset that this court held was more just but not legally required, and that fee agreement is found at docket number 563-1. There's simply no basis to find that the defendant's agreement violated public policy as articulated by this court, or that it was so manifestly injurious to the public that it should be deemed void and unenforceable. Your Honors, no court has held that an assignment of the right to collect statutory attorney's fees is against public policy, void, or unenforceable, and certainly no court has held that the existence of any such assignment constitutes a breach of fiduciary duty. The district court correctly barred the plaintiff from offering expert testimony that the retainer agreement in this case was void and or against public policy and or constituted a breach of fiduciary duty. We respectfully request that the district court's orders be affirmed and that the court's order entering judgment on the jury's verdict be affirmed as well. Thank you, Your Honors.
Thank you, counsel. Anything further, Mr. Mandel?
Yes. With all my heart, I want to answer.
You need to come to the rostrum before talking.
I want to make sure that I answer all the court's questions. There seems to be some concern as to whether federal or state law applies. Every case that we've cited that reviewed an assignment of the right to collect attorney's fees under Section 1988 or the Equal Access to Justice Act or some other prevailing party claims have all found, relying on Pony, that such assignments are unenforceable. Illinois state law says all claims, all personal injury claims, are unassignable. There's no conflict between.
Thank you, counsel.
Very good.
Your time has expired, counsel.
Oh, I thought I reserved.
Your time has expired,
Your Honor,
counsel.
thank you for your time.
Our next case for argument is Mitchell against ExxonMobil Corporation. Ms. Abraham.
Thank you. Good morning. May it please the court. My name is Christina Abraham, and I represent the plaintiff appellant Kara Mitchell in the matter before the court. We ask this court to reverse summary judgment and remand for trial as the record contains evidence that Ms. Mitchell's termination was the result of gender discrimination. It is undisputed that Ms. Mitchell meets elements 1 and 3 of a prima facie claim under McDonnell Douglas. She's a woman and her employment was terminated. The court improperly dismissed evidence that she meets element 2, that she was meeting her employer's legitimate performance expectations. The court improperly dismissed evidence that Ms. Mitchell meets element 4, that she was treated less favorably than her comparators, who are not female. And the court improperly dismissed evidence of pretext. And because this analysis merges with the second element, I'll discuss pretext together with the second element. The district court credited Exxon's rationale for improperly drew inferences in its favor, rather than viewing the facts in the light most favorable to Ms. Mitchell, as is required under Reeves and Anderson. Although the court should review the record as a whole, per Reeves, it was required to disregard all evidence favorable to the moving party that the jury is not required to believe. Credibility judgments and weighing of evidence and drawing reasonable inferences from the fact are all functions of the jury. And if there is a genuine issue of material fact as to any element of the claim, per Celotex Corp., summary judgment must be denied. And because there were genuine issues of material fact as to 2 elements of the claim and to pretext, summary judgment should have been denied. Ms. Mitchell was meeting her employer's legitimate performance expectations. Her initial preliminary performance rating was a B. Mueller and Hayes, her supervisors, initially ranked her as a B, which means a strong contributor.
Why wouldn't the final grade of the D control?
Because that process in and of itself was highly influenced by the preliminary assessment. Every person in her peer assessment group left with the same preliminary rank, the same rank that they were preliminary assigned. And so the preliminary rank and the way that she was discriminated against in the assignment of that preliminary rank shows that she was discriminated against. It sealed her fate.
Your argument, those Ipsy Dixit, we've got a huge company with tens of thousands of employees with a written policy as to how it goes. And I'll be honest with both parties, it's complicated. And for us to really understand it takes a lot of time. Once we do, there's these various steps that occur. You haven't challenged the nature of the company's review process. That's not at issue. You're saying the way the company applied the process here was discriminatory.
Precisely.
On elements 2 and 4. And you're saying there's genuine material fact with regard to those 2 elements. You've got to explain to us, though, how the final grade would be discriminatory. Because the process provides for both a preliminary assessment and then the overall assessment at the end.
Yeah. So there were a lot of deviations from the policy as it was written and in practice. Number one, the preliminary assessment is derived from a self-assessment that's done by the employee, and then there are knowledgeable other feedbacks that their peers provide for them. And then from that, a preliminary assessment is given from the local supervisor.
You're describing it to me, but tell me what the problems were when it got to the level of the final grade of D.
I think that part is a red herring, because that preliminary grade that she was assigned, along with everybody in her peer assessment group, is the grade that she left with. And it's the local supervisor that presents at the peer assessment groups. And they're supposed to present on things like the self-assessment and the knowledgeable others feedback.
What evidence do you
forms, but they
have
didn't.
that the final meeting was discriminatory?
The final meeting is a red herring. The preliminary assessment is
Let me
what
try to
seals
ask
her.
the question again, okay? With the stage that we are in regards to the litigation, what evidence do you have to support the conclusion that it's a red herring?
The fact that every employee in that in the peer assessment group left with the same rank as a final rank that they entered with. In other words, that the preliminary rank that the supervisors gave them was determinative or highly influential, such that in Ms. Mitchell's case, it tainted the process for her.
I don't think that's correct, because
That's
one
not
went from a
correct.
B to a C.
Say that again?
One went from a B to a C.
No. No, Ms. Mitchell was first assigned a B.
Right. She
Then-
ended with a D.
Then after it was determined that one of the local lab techs had to receive a D, which is a deviation from the process, she was the one that was selected to receive the D, even though a male employee, Daniel Pitts, was preliminary assigned a C.
But why do you say that that was mandated by the process?
That was not mandated by the process.
That someone had to get a D?
That was a decision that was arbitrarily made. That was a deviation from the process. There is nothing in the policy that requires it, and moreover, nothing in Mueller's own Northern Cluster group that shows that that was applied to anybody else.
Well, we don't have the responses by Sanchez to the emails, though. So
Correct.
we know that it's coming one way, but not the other. We don't know the second half of that story as to why someone had to get a D.
I think that is what raises the pretext. It's the deviation from the practice and the policy that raises a reasonable inference that there was pretext. When the decision was made, somebody had to receive a D. That was not part of the process.
How does that connect to her? How is that connected to her sex then?
Because she was in a group of 3 employees. She was the only female, and she had just been, before it was determined somebody had to receive a D, she had been assigned a B, which was higher than Pitt's. So under an objective assessment, a reasonable jury can infer that her supervisors, Mueller and Hayes, thought that she performed better than Pitts and at least equal to Aguirre.
But the assignment group is different than who she was working with at the location. So the assignment group did have a female in it, Terry Davis.
She was assessed by different supervisors. So unlike Juan and Palombo, she was assessed by different supervisors.
Didn't the supervisor lose his job as well?
Are you talking about Jeff Hayes?
Yeah.
He did eventually, but he's a supervisor that worked at a different plant. We have no idea, and nor is it relevant, I think, why he was removed. But what I will say is that Karen Hasberger, who was Ms. Mitchell and the other 3 lab techs' direct supervisor at the Cicero plant, just months prior, herself was also let go through that MLRP performance assessment process and replaced by a male, just like Ms. Mitchell was replaced by a male. So I think that per Rudin and per Reeves, she's met the prima facie elements of her case, and she's shown evidence of pretext in the sense that she can show that her supervisors thought that she performed better than Pitts initially.
She received a D.
She first received a B when
But
Mitchell
the
acquired.
very word preliminary means exactly what it suggests. This is preliminary. Until we have brought all of the employees in this particular assessment group together, we will assign the final grade. Is it your suggestion that because her grade changed, it must be connected to a discriminatory reason?
It's my argument that reasonable inferences could be drawn in either way, and that's why it should have gone to a jury. Because she was initially preliminary assessed at a B, because we can see that the preliminary assessments were determinative of the final outcome, and that peer assessment group meeting was a formality to just rubber stamp the preliminary assessments. And we can see that because every single person in her peer assessment group left with the same grade that they started with. In other words, she was never going to stand out amongst her peers with a D and them having a B. Your Honors, I would like to answer any other questions that you have, but I'd also like to reserve the rest of my time for rebuttal.
Certainly, counsel.
Thank you.
Mr. Duffy.
Good morning, Your Honors. May it please the Court. My name is Patrick Duffy, and I represent Defendant Appellee ExxonMobil Corporation. This Court should affirm the decision of the District Court granting summary judgment in favor of ExxonMobil, as there is no evidence from which a reasonable finder of fact could conclude that the termination of plaintiff's employment was the product of unlawful discrimination.
So we understand the hierarchy of the company, Mr. Duffy. Hayes supervises Mitchell, and Mueller supervises Hayes. Where does Sanchez fall into that hierarchy?
Sanchez does not fall directly in that hierarchy. He had no supervisory authority over Mitchell at all. He's the plant manager of the Cicero plant, and he reports up to Hank Mueller, the same way that Jeffrey Hayes did, but no direct supervisory authority over plaintiff here.
So why is his information important for purposes of the consideration of her review? Because he's the supervisor of Cicero?
So Sanchez had no involvement at all in plaintiff's performance assessment. He was asked to either confirm or realign Hayes' thinking, since Sanchez is on site there at Cicero while Hayes is not. But there's no evidence in the record whatsoever that he ever responded to that. No evidence that he participated in the assessment group meetings or participated in the assessment group meetings of any other office clerical employee that is the category that plaintiff fell into here.
And we don't have his response emails, but we know he's being consulted, so he's got some role, right, Sanchez?
Not necessarily, Your Honor, and that's in particular with respect to the final assessment that takes place here. He had no involvement in that at all. He may be able to provide some insight, and that was what he was consulted for. Confirm or realign my thinking were the exact words of the email. But he has no direct role in the process here because he had no supervisory authority over the employee.
Confirm or redirect my thinking sounds like they're asking for his thoughts and his input.
Correct.
And we don't know what that was.
You're right, but his testimony was that he doesn't recall receiving the email, he doesn't recall responding to the email, he doesn't recall ever weighing in on the question that was asked. So Hayes was reaching out to try to get some feedback from a person who's on the ground there in Cicero, and there's no evidence that he ever provided that feedback and had no role in the feedback process here. So it's a decision that was ultimately made by Jeffrey Hayes in terms of how he would assess the employees under his supervision in the Cicero lab. And the only evidence in the record about how he came to that determination was based on his personal review of each employee's strengths and contributions throughout the year. There's absolutely no evidence at all that he did not honestly believe that assessment. So there's no evidence of pretext and no evidence that gender played any role whatsoever in the decision here.
Well, he lost his job too, right?
Well, Jeffrey Hayes did lose his job as well, correct. He was assessed as the equivalent of a D for his employment category and opted to retire under under ExxonMobil's processes.
Can we presume the pay in lieu requirement includes not just a non-disclosure agreement, but an agreement not to sue?
Your Honor, it does include a release of claims, that's correct.
Okay.
So ultimately, the primary issue here is that there is no evidence in the record whatsoever that gender played a role in the termination of plaintiff's employment. You know, even looking at her coworkers in the Cicero lab, Pitts and Aguirre, there's no evidence that they're proper comparators in the context of ExxonMobil's assessment process because they were not in the same assessment group. And as Judge Breyer pointed out, there is no evidence at this last stage of the process that there was any discrimination in that process. And in fact, the other female in the group performed just as well as the two males in the group. So that defeats any sort of inference of discrimination or that process was discriminatory. And also to briefly address some of the broader evidence regarding the record as a whole. There's no evidence considering the record as a whole of any sort of pattern or practice of discrimination. The district court properly concluded that the materials that plaintiff attempted to rely upon from separate litigation between the parties was properly excluded because they were never disclosed as part of the Rule 26 disclosures. The district court did not abuse its discretion because it was a straightforward application of Rules 26 and 37 of the Federal Rules of Civil Procedure. Nevertheless, the court also took those materials into consideration and found that they did not support any sort of finding of discrimination here, which is the same conclusion that the court in that separate case came to, that those materials did not support any sort of inference of discrimination. And so viewing the record holistically here or under the McDonnell-Douglas burden shifting framework, the district court properly concluded that there was no evidence of discrimination. And unless the court has any further questions, I'll cede the remainder of my time and will respectfully request that the court affirm the decision of the district court.
Thank you.
Thank you very much. Ms. Abraham, anything further?
Just a few points for rebuttal. Sanchez's failure to recollect doesn't rebut the reasonable inference that a jury could make that when his supervisors asked him to provide input, he provided it, and shortly thereafter, Ms. Mitchell's rank was lowered from a B to a D. And when Ms. Mitchell was asking for the reason for her ranking and termination, McGuire from HR directed her to Sanchez for answers. The lack of standouts justification came for the first time from Sanchez 2 months after the final assessment had been made.
Sanchez was deposed, correct?
Correct, yes.
How long was that deposition?
Oh, gosh, I can't remember, but it was at least 5 hours.
Oh my God, okay.
Yeah. Exxon wants to draw rigid lines around comparator groups, but Coleman and Humphreys instruct otherwise. Ms. Mitchell, Pitts, and Aguirre were similar enough, and there is evidence to show that the preliminary ranks were determinative of the final outcome. The distinctions go to weight and not admissibility and are therefore for a jury to evaluate. Intent can be shown circumstantially. That's why we have an indirect method of proof. Managers deviated from Exxon's own ranking process. They contradicted their own initial assessments of the lab techs, and the people who applied the policy did so in a way that targeted Ms. Mitchell. This is classic pretext under Reeves and Ortiz. So she wasn't let go because of performance, and with that, I would ask the court to reverse summary judgment. Thank you.
Thank you.
Thank you, counsel. The case is taken under advisement. Case number 5 for argument today is Bork against Collins.
Good morning, Your Honor. Good morning.
Mr. Flaxman.
Thank you, Your Honor. May it please the court. This is a Rehabilitation Act case, Mr. Burke had been employed by the VA in June of 2019. He asked for a reasonable accommodation for his disability. The VA granted that accommodation and gave Mr. Burke a parking space adjacent to the door that he would enter the hospital. In March of 2020, the VA closed that door as part of the COVID stuff. Mr. Burke arranged an informal accommodation, which he continued to enter through that door for about 2 months. In May of 2020, Mr. Schreier, who's the Human Resources and Reasonable Accommodation Specialist, became aware somehow that Mr. Burke was still entering the door and told the VA police, don't let him enter the door anymore. Mr. Schreier did not initiate any discussions about how Mr. Burke could be reasonably accommodated. He waited for Mr. Burke to ask for a reasonable accommodation. The legal question in this case is that allowed? May an employer rescind?
Mr. Flaxman, what remedy are you seeking?
Damages for having to walk for that, I think, from May 14th of 2020.
And so what should we do about Lane against Pena, which holds that the Rehabilitation Act does not authorize damages against the United States?
I was fearful coming before the court because I knew there was something that I missed, and Your Honor pointed it out. I don't know. I haven't thought about that. It wasn't raised below.
But the Supreme Court has thought about it.
I would like an opportunity to think about it and give the court my views on that, because
If we think we need further briefs, we will let you know.
We were entitled, there were EEOC cases that we cited in the agency where money damages were awarded for under the Rehabilitation Act. And that wasn't raised by the government. And
Is it waivable or not?
if it's jurisdictional, it's not waivable.
Is it jurisdictional or not?
If it's jurisdictional, it's not waivable. I will ask for leave to submit a memorandum on that point.
We will let you know if we want further briefing on that point.
And I will wait for any other questions.
No, you could go ahead and discuss the merits, because this is your only opportunity.
If the court doesn't have jurisdiction, we're all wasting time discussing the merits, but I will plow ahead because lawyers always like to talk. And I had a good breakfast this morning.
And we're not going to ask you to move back.
Case number one.
All right, I was here. If there's no relief that we can get, well, if we're entitled to a declaratory judgment that they violated his rights, Mr. Burke is entitled to attorney's fees, I would argue. And that would not be damages, that would be the nature of equitable relief.
No, the Supreme Court has expressly rejected the argument that a request for attorney's fees keeps a case alive.
I will.
If you want to discuss the merits, this is your only opportunity.
I understand that, but if the court lacks jurisdiction,
all right. We're not compelling you to do anything, Mr. Flaxman.
I know, but if I'm wrong about jurisdiction, and Your Honor is right, as is often the case when I come before this body, I'm wasting time arguing the merits. I will stand on the briefs, which I think are well present the issues. Thank you.
Thank you, Mr. Flaxman. Ms. Flores. So, is Lane against Pena jurisdictional? Because you certainly didn't stand on it.
We did not stand on it. Our understanding is that employees are entitled to back pay or up to $300,000.
Yeah, but there is no back pay.
Correct, not in this case.
There's only damages.
Yes. Yes. And so, as Mr.
And Lane against Pena holds that The Rehabilitation Act does not authorize damages against the United States. The Supreme Court has been saying in recent years that sovereign immunity is jurisdictional. We have held otherwise, but may be overtaken by recent authority at the Supreme Court.
Yes, Your Honor. I understand some of the case law on jurisdictionality, but we did not address the Lane case.
I know you
issue,
didn't. That's
so-
one reason why I raised it. The
Yes.
parties haven't mentioned what seems to be a smack dead-on controlling decision of the Supreme Court, ignored by both sides.
I can only say, as Mr. Flaxman said, that I'm happy to brief the case if the court wants us to address it.
All right, well, if we think we need more briefs, we will let both sides know.
Okay. May I just state very briefly then regarding the merits? The VA fulfilled its obligations under the Rehabilitation Act when it replaced one reasonable accommodation, the plaintiff's original parking space, with another reasonable accommodation, the same temporary accommodation being used by 2 other VA employees in response to a global pandemic. And as the district court correctly found, the plaintiff did not present evidence that the offered accommodation was not reasonable.
Was there an interactive process that occurred here?
There was. So, yes, there was an interactive process, to answer your question directly. The how it came about was perhaps a little unusual given the circumstances of the pandemic. So Mr. Schreier's testimony, referenced by Mr. Flaxman, was that he became aware that someone was entering that back door without the screener. It was not necessarily identified as Mr. Burke, and that they locked that door. So after the door was locked, they found out that it was the plaintiff who had been entering the door because he notified the police, I believe, and the coordinator that he had been locked out. At that point, they began the interactive process anew right away. Within days, they identified the new reasonable accommodation. And unless the court has any further questions, we ask that you affirm the district court's decision. Thank you.
Thank you, counsel. Anything further, Mr. Flaxman? All right, the case is taken under advisement. Our final case of the day is Castillo de Molina against Bondi.
Good morning.
You let both lawyers find a seat. Mr. Quincheno.
Good morning, Your Honors. May it please the court. William Quiseno on behalf of the petitioners Alba Castillo and her 2 children. This case arises from procedural and substantive missteps that, taken together, deprive the petitioners of a fair and meaningful opportunity to present their claims. We respectfully submit that the board's denial of the motion to remand was arbitrary, capricious, and abuse of discretion, and contrary to the law. The board failed to apply the correct standard of review when assessing the prejudice resulting from the ineffectiveness.
Counsel, let me just go for the straight line here. Your client checked a box saying a brief will follow. And that box is accompanied by a warning saying, if you check this box and don't file a brief, we're going to summarily affirm. What's wrong with following through on that very promise?
I think we could distinguish our case from Coker and Cortina.
I'm not asking about other cases. I'm asking why the board can't follow through on a promise. The appellant makes a promise to file a brief and is told the consequences of not keeping that promise. She doesn't file a brief, and the board follows through. Why is that legally forbidden?
Well, a pleading was filed. It might not have been a brief.
A brief.
Might not have been a brief.
Look, the thing that was checked says, I'm going to file a brief.
And the rule requires a brief or a statement, right? And you know, we could have titled the motion brief, or we could have titled the motion statement. But the argument, the main focus of the appeal would all have been the same, whether we had called it a brief, whether we had called it a statement, or as we call it, a motion to remand.
A brief contains argument. The statement of issues filed before the board indicated the alien's bottom line, but didn't have legal argument, which a brief has. Look, we're not going to abolish the distinction between briefs and other documents. So let me repeat my question. Your client checked a box that said, I'm going to file a brief, acknowledging that if no brief was filed, that's the end. Why is the board legally forbidden to keep that promise?
Because the notice of appeal was sufficient. It disclosed what the error was.
Then don't check that box.
Understood.
You're not dealing with my question.
Understood. Yeah, the heart of this appeal is how an attorney's substandard work throughout the 7-month period was so fundamentally flawed and unfair that it prevented Ms. Castillo from presenting their case. From initially preparing what the immigration judge at the initial hearing called a bare bones application, to preparing everything at the 11th hour, the attorney was ineffective in representing the petitioners, and the board should have remanded the case before issuing a decision. The BIA, the board, found that this attorney was thorough and complete in their representation of the petitioners. He missed every briefing schedule, every filing deadline, every procedural requirement, despite being admonished at the initial hearing by the judge to pay close attention to those deadlines, to timely file those documents. He failed to comply with the simplest of fingerprint and biometric instructions, which resulted in the petitioner's claim being dismissed, despite, again, at that initial hearing, the judge admonished him about the biometric requirement. And what did he do at the 11th hour? He invented a malarkey of a story that he had sent this request 4 weeks ago, and that there was this USCIS backlog regarding the biometrics. But what we learned from his ARDC response, he disclosed his own lie, right? That he had actually submitted it the day before the hearing. He failed to assist the petitioners in preparing a well thought out and organized sworn statement. He failed to meet with the petitioners to prepare for their testimony. In fact, he told the petitioners that her case had been continued when in fact it had not been continued. And at the 11th hour, with less than 48 hours to prepare, he tells her, you have to come to this hearing. He doesn't meet with her. He doesn't prepare her. Had the attorney performed adequately, the record would have been different. Asylum cases are complex, and the most important part of any asylum case is an individual's sworn statement. That's where you get the heart of the claim. And what does he do? He sends her a guideline, she responds, and he submits what basically a pro se litigant would submit in a case. Why have an attorney? Why pay $8,500 to put a statement that you haven't reviewed with your client, that you haven't asked follow-up questions? There's more information there. It's basic lawyering 101. You ask, you draw out the facts of the case that are going to support your claim. He did none of that, and as a result, her case was denied. And initially, the immigration judge denied the case for the simplest of procedures that he missed. I'll reserve my time.
Thank you. Mm-hmm. Thank you, counsel. Ms. Slack.
May it please the court. Petitioners raised two challenges. They challenged both the board's summary dismissal of their appeal as well as the denial of the motion to remand.
On the first,
Do we have
I'm
jurisdiction?
sorry.
I'm sorry. Do we have jurisdiction on the second point? The motion to remand?
Yes, Your Honor, you do.
Is that a discretionary decision?
It's a discretionary decision, but it's a discretionary decision that's not made discretionary by the statute. So under, the case name escapes me, Supreme Court case, that in order for that jurisdictional stripping provision to apply, the matter needs to be made discretionary by the statute itself, not by regulations or by board case law.
On the first question, the summary dismissal, what do you say our standard of review is?
I would say, this court hasn't reached it yet, but I would say that it's abuse of discretion, given the permissive nature of the regulations that are being applied to summarily dismiss in this case.
So there's not a particular authority that you're going to cite, or you're just indicating that's where you believe our standard should rest?
Well, this court in both Kokar and Cortina Chavez declined to address what the standard of review is, finding that it was so clear that the failure to file the brief that was promised is sufficient basis that it didn't require addressing the standard review in that situation. I would argue the same is true here, but to the extent that the court wants to know the government's position on what the standard review is, I would say it's abuse of discretion given the permissive nature of the statute.
Thank you.
You have two challenges here, but both of them have one thing in common. There's really just nothing behind the curtain. There's no there. Petitioner argues about the ineffectiveness of prior counsel, yet nowhere in the motion to remand and nowhere in their brief do they say what would have been different if you had a more competent attorney. What evidence would have been offered? What would actually concretely be different? They just list categories of things that would be different. And most of what we heard from petitioner's counsel at the opening argument was related to the biometrics requirement. But the biometrics requirement and failures of counsel to supply that in a timely basis isn't really material because the immigration judge made an alternative decision on the merits itself. And the immigration judge went through the entire case and on several different criteria found that petitioners were not eligible for the relief and protection that they sought. And there's nothing in the motion to remand or their brief that tells you what would have been different. And so it doesn't really get out of the gate for purposes of being a motion to remand, which in this nature would be a motion to reopen, because we've got nothing new here for the board to say that something possibly could even be different if the case were sent back to the immigration judge. So we don't really even need to address the standard for ineffective assistance of counsel in this case, because we don't get out the gate of what's required for a motion to remand itself. The same is true with regard to the argument that the notice of appeal stated sufficient grounds. All it does, like the motion to remand, is list categories of things that they take issue with, but then they never explain in the statement what the issues are. They never develop an argument. They never assert an argument. In fact, largely what's in the notice of appeal is a mere description of what the immigration judge's, what evidence the immigration judge considered and what the immigration judge's decision ruling was. It doesn't really tell you. It doesn't take you from that to what was wrong with it. And so for that reason, even if you do address the question of the adequacy of the notice of appeal, there's no there either. But to start with, on that question, summary dismissal, under Kokar and Cortina Chavez, it should alone be enough that they checked the box, that they were going to file a brief, and they never filed the brief. Petitioner makes the argument that, well, they filed a motion to remand, but that argument also fails for three primary reasons. First of all, the board separately considered the motion to remand and issued a ruling on the motion to remand. So it's not going to be sufficient that you filed a motion to remand on ineffective assistance of counsel, and that somehow is going to preserve the rest of your appeal. Two other reasons, that the receipt for the motion to remand explains to petitioners that that is not a substitute for a brief, and that you still have to meet the obligations of a briefing schedule if one has issued, as has in this case. And then we look at the motion itself, and they did not treat their motion to remand as if it were a brief. It doesn't say in lieu of a brief, it doesn't say and brief, it doesn't address that at all. And if the court has no further questions, I will return the remainder of my time. With that said, we ask that you affirm the decision of the Board of Immigration Appeals, just summarily denying the appeal. And
Yes, thank you, counsel.
thank you.
Anything further?
Just briefly, yes, the immigration judge in the alternative reviewed the asylum claim. But initially, she had already dismissed the case. And so I think it ends right there. And we ask that you sustain our appeal.
Thank you very much, counsel. The case is taken under advisement and the court will be in recess.